Court action to reveal South Africa's role in Yemen's civil war. An urgent two-part application has been launched in the North Gauteng High Court. The application seeks the names of all permit holders who've been authorised to export arms to Saudi Arabia and the United Arab Emirates. The Southern Africa Litigation Centre and Open Secrets say that the South African government has failed to stop export of arms despite well-documented violations of international law and a rising trend of states suspending arms exports to Saudi Arabia and the UAE. Lawyers for Human Rights Deputy Director Wayne Ncube joins me now to discuss this further. Wayne, very good evening to you. Tell us more about this court action and what do you hope to get out of it?
Yes, so what we're hoping to get out of it is stopping South African companies from shipping arms to Saudi Arabia and the EAU, who are parties to the Yemen conflict, which is one of the worst humanitarian crises. The National Conventional Arms Control Committee is meant to grant permits which enable the transfer of arms to other countries, but the decisions in granting those permits have to be rational and constitutional and meet international law and avoid aiding conflicts like the conflicts that we see in the Yemen, where the EAU and Saudi Arabia are focused on. And so ultimately the goal is to ensure that the administrative decisions by the state in granting permits is done in a lawful manner and in a way that will not make South Africa contribute to that humanitarian crisis.
I mean, I know Open Secrets has done fantastic work there over many years. They know some of the players who are selling arms there. What is it that you want to know about them? I mean, are there other companies that you suspect is behind this that are possibly hiding behind something else?
So the focus of the application really is more around the state and the state body that's meant to regulate the sale of arms, and not necessarily the arms companies. Obviously, if arms companies are selling permits to that contribute to that conflict, they'll be affected by the application, and therefore the court needs to be aware of who it is, which is why we need basically the National Conventional Arms Control Committee to provide that information so that they can be properly cited, and so that should the court agree with us, that the permits that those companies have received are then properly revoked and that those arms stop.
And it comes at a good time, considering that the US and many other countries are prohibiting sale of arms. We know that the US, France, the UK, they've provided arms to the UAE and Saudi Arabia, it's been proven that they are used in Yemen's civil war.
Yes, no, definitely. And, you know, there's so many reports, the UN expert reports, which show that essentially Saudi Arabia and the EAU are responsible for violations of human rights and international humanitarian law, which is why other international countries have stopped shipping arms there. And it's also well documented how the gravity of that particular conflict, which has gone on for over a decade now. Essentially what South Africa has also noted the human rights violations that are taking place in Yemen. And so to be kind of logically consistent with their view of that conflict, basically the control committee has to be making the same decisions in line with our constitution and in line with this enabling legislation. This is really about South Africa's laws and ensuring that they adhere to, so that we are consistent with the way in which other countries are treating this humanitarian situation.
Good. I mean, I know Open Secrets has also claimed that they can prove South Africa's arms have been used in some atrocities against the civilians there. As you were saying, it's one of the world's worst humanitarian crises. I mean, hundreds of thousands of people are dying of starvation. Do we have any idea, though, of the extent of the sale? How many of South Africa's arms are there, and what does that comprise of?
So the information we have currently is quite limited and also a bit of it speculative, which is why a section of this application really is about ensuring that the regulator makes open this information so that the courts were essentially our safeguards in ensuring that legislation is followed. is aware not only of the external crisis of what the legislation says about what's meant to happen, but also of the companies that have been granted these permits, which, in our opinion, has been done in an unlawful manner, so that all of it can stop.
And sorry, very briefly, what does a company have to do?
For me to give data on those figures.
Okay, what does a company have to do to be granted a permit like this?
Yeah, so what companies do is they make their applications to the National Conventional Arms Control Committee, and then and they'll set out where they want to basically transfer their arms across the world. And what the Controls Committee has to do is make sure that those arms are not contributing to a regional conflict, are not going to countries that are essentially have been reported to be committing serious human rights violations, which both the EAU and Saudi Arabia have been known to be, and are not going to be part of a conflict where humanitarian law is being abused, which is what's happening in Yemen, along with a lot of other regulations. But that's a specific part of the National Controls Act legislation that we are concerned with. And obviously, if the regulator was still giving permits, well aware of what so many international reports are saying, then it means that they haven't carried out their job properly, and either their decisions are irrational or, at the very least, unconstitutional. And which is why we want the courts to have a look at it and hopefully overturn it.
Wayne, thank you very much for that.